Let's do something on the law and the courts. And one of the 12 High Court judges cited in the judicial bribery scandal has filed a suit to stop the public airing of the audio and video footage slated for the 22nd and 23rd of September. Justice Paul Derry filed a suit at the Accra Fast Track High Court against Anas Arimea Anas, challenging the legality of the intended public screening of the video. The suit is also seeking an injunction on the video because the alleged visual recordings constitute a breach and transgress all rules of justice, fair play, and equity. A statement of claim accompanying the writ of summons averred that the premiering of the alleged video and audio visuals at the International Conference Center on September 22 and 23 will be illegal and only meant to incite public hatred against the plaintiff. And joining us on the line to find out how this is likely to pan out, or the possibility of the court accepting video or audio evidence, is lawyer Yao Opong. To start with, how do you obtain... No, well, let me rephrase. When you are tendering in an evidence in court, and in this case, we are looking at audio or video, what are the things that the court looks out for before they can accept it as an exhibit or as an evidence?
Okay, thank you very much. I think the basic fundamental principle on evidence, acceptance or otherwise of evidence, as I understand it, is whether or not it is evidence which is relevant to your case. And if it's relevant, then it may be received in evidence. The next question is, what weight must be put on that evidence by the judge? And so there has been a debate as to whether or not in that matter, the manner by which the evidence was obtained and the nature of the evidence really matters in either case. Some have argued that it is documentary evidence which prevails over oral evidence. In fact, there is sufficient authority to the effect that where documentary evidence contradicts oral evidence, then the documentary evidence will prevail over oral evidence. Now, the third aspect is, if it's not oral and it's not documentary in terms of hard copy on a paper, then videos, and these days with technology, other soft copies of evidence also will suffice. I think that they will. And indeed, recently, our rules have been changed or have been amended to accommodate the taking of evidence in the form of even TV evidence. So you remember that during the presidential election petition, the court proceedings were taken on the field view of the people on TV.
Right.
Also, the law, the Constitution, for example, will also permit a commission of inquiry to take evidence from witnesses abroad. Such evidence, which may be in soft copy, in my view, if it's authenticated, will be received in evidence if it's relevant to the particular case or issue before the court.
There is also the argument, or the bit of the argument, where the concern of how the evidence is gotten or how it was obtained. Or yes, what is the legalese around this? How do you prove that this was the right way or the wrong way of obtaining the evidence? Okay,
the basis is the reference to the Constitution itself, Article 18(2), which says that no person shall be subjected to interference with the privacy of his own property, correspondence or communication, emphasis, except in accordance with law, as may be necessary in a free and democratic society for public safety or the economic well-being of the country, for the protection of health or morals, for the prevention of disorder or crime or the protection of the rights or freedoms of others. So under these circumstances, where a person obtains evidence and he can show to the satisfaction of the court that he did not seek the consent of the person, maybe by way of their communication, that he indeed interfered with their privacy, that he can justify that act on the basis that, let's say, the people were planning to commit an offense. The people were planning to themselves also breach the rights and freedoms of other persons. That the acts they were engaged in or they were planning to do would cause detrimental effects to the economic well-being of the country. Will also be contrary to our quest to ensure that the health and morals of our people are secured. Under these circumstances, it has been argued that it does not matter how the evidence was obtained.
Okay.
But some still say that, those who oppose it say that there must be a specific law that entitles you to do so, and it must be in accordance with the tenets of democracy and free society. In other countries like the UK and the US, they have passed specific laws to regulate how evidence is obtained.
All right.
We have not done so, and under our Evidence Act, it appears that evidence will be received in the trial if it is relevant, and it may not matter how it was received. So I would say that it is still a raging controversy, and we as lawyers have not yet, in my view, settled finally on it.
Okay. We are grateful for your time. There is also the bit about the conference center, the injunction being placed on it, and also the journalistic ethics as against how this evidence was obtained. But for lack of time, we'll have to leave it here for now. Thank you very much.